All right. What's going on, party people? This your man Griff. I'm just sitting here making sure I got everything squared away. All right, let me zoom this in a little bit here. All right. Um, thank you for always liking, sharing, commenting, and greatly appreciate you 100%. All right. This here is a little bit of a follow-up to the video that I did a couple of days ago. This video here talking about notarizing Georgia security deed by non-Georgia notaries. Okay. And I went into this, well, not deep, but I took my time and went over 59 minutes and 25 seconds of information about Georgia documents, or the deed and their laws and their statutes, or then they call them codes, as to that fact that they can be notarized in accordance with your state law. And it was interesting that a couple of comments came in basically saying, oh, no, it has to be done in accordance with that state's recording requirements. Now, and the link is in the description to this here. So y'all make sure y'all take a look at it. If you haven't already seen it, I'll put a link over here for it. Here's the thing. We have to be careful when we say, oh yeah, notary's supposed to do stuff based on that state over there, but I'm not in that state. I'm not in that state. Okay, that's the whole point of that video, was you have to do things in accordance with your state laws. It was a good comment. I get what they're saying is like, oh well, you have to do it in accordance with their recordation laws in that state. Well, one of the other things that a lot of people don't take into account is that the recording requirements sometimes aren't state based, they're county based. Each county has a different set of requirements. I did a video a while back talking about Florida. Florida has a new thing, basically saying that, and I'll put that link right here and make sure I don't forget it. 230 something more. Florida Lee County. Okay, so I don't forget. Because y'all know I be forgetting stuff sometime. Um, so so that link will be up there that you just saw a few seconds ago, and it'll be in the description. But in that video, I talked about the fact that Lee County, Florida, is doing their own thing and testing out something as to whether or not they want to use they require ID, the physical, a copy of the ID, so they can see who the person is that actually signed off on this deed. A lot of the recording requirements are county based, and Georgia has 159 counties. So how can a notary learn all 159 requirements for a particular state? We can't. That's not our job to know the recording requirements. We know what the notarizational requirements are from the state. The state sets that. The state says this is how you're going to notarize signatures in our state. The other person also made a comment, and I get where they're going with this, but they said, well, use the primer for that state. The problem is the primer isn't designed to help you understand the recordation requirement. It's designed to help you to understand the notary's role and how we're supposed to properly notarize signatures on the documents, not what the requirement for that state is to, or that city or that county, for recording the deed at the courthouse. That's not our job. Just like it's not their job to monitor the notarizational aspect of it. So there's no way we could ever be that knowledgeable to know all of the different counties, or even if it was state based, that's 50 states that you got to sit here and know how that state wants things recorded. Because if you go and take a look at California, California has certain things in their notorious take, like they can't do capacity, meaning you can't do like Jane Jones, the attorney in fact. You can't do that in California. I can do it in Virginia, but you can't do it in California. So they don't do notarizations for capacity, meaning somebody doing something on behalf of another. So that's why I'm saying you have to learn that part first. You can't sit here and say, well, we're just going to do it in accordance with what they want. How? Okay, so let me show y'all let me show y'all these two real quick. Um, Hope you can just bear with me. So let me pull this up. All right. So this here is from Superior Notary Services. The links will be in the description. Notarizing out-of-state documents. What you should know. So, as a notary public, you might be wondering whether you can legally notarize documents from out-of-state clients. A client may receive a document in Texas, and I guess this is I guess maybe that's where they're based at. For instance, and then travel to Florida to request a notarization. So the person got the document while he was physically in Texas, and then went on travel, and they ended up in Florida and needed it notarized. So, being that law governs notarial acts within the U.S., being being that laws governing notarial acts within the U.S. vary from state to state, that's right here. It's important for the notary public to familiarize him or herself with their respective state laws conduct before agreeing to conduct a notarial act. Okay, let me zoom this in a little bit more, make sure we see this. Okay, so let's go back to this here. Being that laws governing notarial acts within the U.S. vary from state to state, it is important for the notary public to familiarize him or herself with their respective state laws before agreeing to conduct a notarial act. So a notary public notarizing, so can a notary public notarize out-of-state documents? The short answer, yes. Notary publics are legally allowed to notarize documents from any state as long as the notarial act is conducted within the geographical boundaries of the notary state of commission. Going back to the example mentioned above, a notary public who's commissioned in Florida can notarize a document that was created in Texas as long as the act is done in Florida. The notary public cannot travel to Texas to perform the notarial act unless he or she is commissioned in Texas. Okay. So that means while you're on vacation and you run across somebody from your state, you just can't do that unless, like Virginia says, we can, provided that the document is going to be used and executed in the state of Virginia. If it's going to be used or executed somewhere else, some other state, and we're not physically in Virginia, we can't do that. Then it says there are some cases in which notary publics are legally allowed to act as notaries in multiple states. Montana, Wyoming, North Dakota are just a few that allow notary publics to act as notaries in bordering states, assuming the bordering state also has this law. A notary public in Montana, for instance, can notarize documents in both Wyoming and North Dakota. Only some states allow this practice, though, so don't assume that it's acceptable throughout the country. Which state laws, what state's laws should I follow? The law of the state in which the notarial act takes place supersedes those of the state from which the document was originated. So at that point in time, how do you say you can't do it? You see what I'm saying? How can you say, well, we have to follow what they want? So if some other state says, well, we want to see this, that, and the other on that notarial statement in order for us to record it, but your notarial statement doesn't meet my state's requirements, then you might as well just end it all, because everybody's just gonna have to stay home and stay in their state to get documents signed and notarized. You could never do it because there's just no way that's going to happen. So it goes on and says this means a Florida notary public would have to follow Florida laws when performing the notarial act on a Texas document, not Texas laws. Don't make the mistake of following the laws from which the document came. Don't make the mistake of following the laws from which the document came, as this can place a notary in hot water. And then it talks about the venue. When notarizing out of state documents, the notary should check the certificate to ensure the state and county listed in the venue section accurately reflect the state in which the notarial act takes place. So if you got a Texas document and you're in Florida, you need to put down the state and county in which you are physically at. Okay, it's that simple. Some certificates may have the information pre-filled with information reflecting the state of origin, but if a client takes the document across state lines, the notary public must change this information, crossing through the line and entering the, the appropriate should suffice. Bottom line, to recap, notary publics are allowed to notarize out-of-state documents. When doing so, however, a notary should follow the state laws of his or her state of commission. It is also important for notary publics to carefully read the wording within the notarial certificate to ensure it actually accurately follows the laws. And it's talking about the laws of your state. I've said this multiple times. If the notarial certificate has the elements that your state law says yours needs to have, then you can use it. If it does not, you add an all-purpose acknowledgement or jurat. It's that simple. And I'm still waiting, and I'm not trying to be arrogant when I say this. I'm still waiting for people to like correct me on this, because I've been saying this for 3 years. And people still like, well, I'm gonna do it the way they said it. Why? Well, that's what they said I'm supposed to do. No, you're supposed to follow your state laws. That's, you see what I'm saying? We have to, there needs to be evidence that we are allowed to do that. And I have not seen that in 6 years of doing this business. But a lot of notaries are saying, oh we have to do it the way this state says or that state says, because that's their requirement. No, it's not. No, I mean, well, it is their requirement, but that is not the case, that we have to do it their way. All right. So this next one comes from everybody's favorite source, National Notary Association. Get this map out the way, but we'll work with it. All right. Let me check this here. All right. So, handling requests to notarize out-of-state documents from 2014. So apparently it hasn't changed since then. Notaries know they are only authorized to notarize in the jurisdiction defined by your state, which in most cases is your state. But what do I do if a signer needs a document, need to have a document, a out-of-state document notarized? Are you authorized to do so? The easy answer, yes. You may notarize out-of-state documents. You are allowed to notarize documents that are sent to or recorded across state borders. Now, let me say this here. Please don't be offended by the way I'm coming across. I'm trying to bring home a point. So don't take it personal. Okay. Nobody take it personal. Wow. Please don't take this personal. Okay. Y'all know this is how I flow. So you are allowed to notarize documents that are sent and or recorded across state borders, provided, of course, that you are notarizing a document within the boundaries of your jurisdiction. It doesn't matter where the document will be recorded, as long as you are following the notary laws of your state. This includes documents of out-of-state real estate transactions, such as purchases or mortgage. Note, our notaries in Kentucky with a special commission may only notarize documents that will be recorded in Kentucky. It goes on and says, check and correct the venue. Be sure the venue, meaning state of, county of, portion of the notarial certificate reflects the state and county where the notarization actually takes place. If that portion of the certificate is pre-populated with with another venue, cross it out and enter the correct information. Know and follow all all your state notary laws. Even when notarizing an out-of-state document, which may have certificates specific to the state where it is being filed, you are still responsible for knowing and following your own jurisdiction's laws. For example, in California, as of January 1, 2013, any document that affects real property requires the notary to obtain the thumbprint of all signers in your notary journal. You will need to record the signer's right thumbprint for every document you are notarizing within the refinance package, since the mortgage deed, a trust, or affidavits of the package affect real property. This law applies regardless of where the property is located, and that's for in-state notaries of California. In other words, you say, well, see, that's what, no, it's California following California law. It's not California notaries doing Florida law. You got me? So it says here to close out, remember when dealing with out-of-state documents, the notary laws of your jurisdiction always supersede those of the state in which the document will be recorded. So, with that being said, again, prove to me that that is incorrect. Prove to me and the rest of us that you can go and do a closing and follow some other state laws, and you can just ignore yours. It's right there. So I don't know what else to say. Um, Honestly, I was hoping I didn't have to put the video out, and I'm not upset at the comments that people said. I'm glad that the comments were made because it helped me to understand. Okay, well, for some, this isn't cut and dry. Okay, let me expound on it some more. So this is where we're at, people. It's up to you whether you want to follow it, not follow it. You're going to do what you feel you want to do. You're going to do what makes you happy. You're going to do what makes you financially happy with getting the orders. So some people are like, well, if I do it, they'll give me more business. So I'm gonna do what they say. And if somebody was to audit, somebody might be going to jail. Somebody might be owing somebody some bigger money than what you ever got paid, what you would ever get had gotten paid for doing it. So I'll put the links in the description. Y'all make it happen. But feel free to give me some feedback. Help me to understand where I missed the mark at on this, if I missed the mark. All right. Y'all have a good one. Can't think of anything else. Talk to you later. Peace.